First off, to explain, there's two types of accounts generally. A joint tenants with right of survivorship account or a tenants in common. Even with a tenants in common account, you might be able to name beneficiaries, maybe payable on death or transfer on death titling. I always tell my clients, if you're going to create an account with only one of your children as the person on the account to write checks for you, try to make sure that you have all of your other children equally payable on death beneficiaries if you want all of them to benefit from that account. A case that I had a number of years ago had to do with a lady that moved to Texas from New Mexico. She moved to Houston to be near her son. He was helping her take care of her affairs. When she moved all of her assets, a lot of her accounts ended up in joint tenants with right of survivorship accounts with her son, both her investment accounts and her cash accounts. It was roughly 55 to 60% of her accounts. When she moved, she had a will written out in New Mexico that said, I want my children to share equally in my estate when I die. Then she passed away. Then her daughter came to me and said, is there anything I can do about this? My mom named me as a beneficiary under will of half of her estate, but all of those accounts are going directly to my brother. The brother and sister did not get along. There was no chance that he was going to share those accounts with his sister, and she realized that it would be too expensive to litigate that issue with her brother. So mother unintentionally disinherited her daughter from a substantial portion of her estate. That was not her mother's intent. My point is this: yes, adding somebody like an adult child to your accounts can be very useful, but be exceedingly aware that you may end up disinheriting your other children if it's a joint tenants with right of survivorship account or if it's payable on death only to that particular person. There are many ways to handle incapacity. There's using the financial power of attorney. There's the use of revocable living trust. There certainly is an appropriate time and place to have somebody added to your accounts. All of those things take consideration, take planning, and should be made part of an overall estate plan. If you're thinking about any of these issues and you would like a free consultation, you can go to my website. There's a button you can schedule a free consultation. We'd be happy to talk to you about these issues and any other issues, estate planning or elder law issues that you might want to address.